Great. As Attorney General, my highest priority is protecting Kentuckians. That's why when I came into this office, I brought a 4-part core mission: preventing and prosecuting child abuse, better protecting our seniors against scams and abuse, seeking justice for victims of rape, and finding workable solutions to our drug epidemic. I do not tolerate those who would profit by misrepresenting their products and by lying or by lying by omission to Kentuckians. That's why, just a couple months ago, we sued Volkswagen for lying to Kentuckians about what they claimed was a clean diesel engine. Today, I'm here to announce that we will be filing suit seeking millions of dollars of penalties against another company that has outrageously deceived Kentuckians. Johnson & Johnson knowingly and deceptively marketed transvaginal medical devices, also known as surgical mesh, to both doctors and women in Kentucky. They failed to disclose a host of dangerous complications that have irreversibly altered the lives of numerous women. Frankly, dangerous is not a strong enough word for what has happened here. The known but undisclosed complications have ruined lives. Women have suffered chronic pain and horrible outcomes, and in many situations the complications are irreversible. One mesh patient stated, "I've experienced excruciating pain from day one. I felt as though my urethra was being strangled. I couldn't use the restroom, walking was out of the question, sitting was agony, and I could not lie on my left side due to the pain. Over the course of the next 14 weeks, I visited and was admitted to the hospital 10 times. I had no quality of life." Over 15,000 women in Kentucky have opted to have the Johnson & Johnson surgical mesh implanted. 15,000. Why? Because neither the women nor their doctors were provided with the knowledge, the information to make a rational and reasonable decision that was in the hands of Johnson & Johnson. Because Johnson & Johnson marketed surgical mesh to doctors, saying it was minimally invasive with minimal risk. And because Johnson & Johnson willfully misrepresented its product, saying that it was FDA approved when it was only FDA cleared. What's the difference? More than 1,100 hours of rigorous testing. And Johnson & Johnson's own employees warned the company of known dangers that the company then ignored. Dr. Axel Arnaud, Johnson & Johnson's medical director, believed the devices to pose such risks that he suggested including a warning to the product disclosure. Johnson & Johnson refused. Another medical director, Dr. Chen, was concerned about the adequacy of the company's disclosures. She reported in her observations that patients, not minimally, but very frequently, reported product exposure, erosion, extrusion, a lack of adequate pre-op consent or risk-benefit assessment, recurring incontinence, and intensity of post-operative complications that was disproportionate to the consent and to the expectations that were raised by the information that Johnson & Johnson was providing. Despite these warnings from their own staff, Johnson & Johnson refused to provide adequate information and never incorporated these concerns from their own staff in their marketing or promotional materials. They were also aware that surgical mesh product posed more potential problems than non-mesh alternatives, and they frequently and repeatedly cited questionable studies. We've heard from women that have suffered in the aftermath of surgical mesh implants, and let me tell you, the stories are awful. They're heartbreaking. It's chronic pain that they experience that prevents the most basic functions. Using the restroom. And we're not talking about discomfort, we're talking about serious, searing pain. Sexual relation difficulty, sleeping, sitting, working, moving. It's caused ruined careers, ruined relationships, and ruined lives. These women could not make informed decisions because neither they nor their doctor was given adequate and known information in the hands of Johnson & Johnson. They were put at risk by a company that put their own profits over the quality of their potential patients' lives. While this lawsuit doesn't seek direct restitution for the individuals, it seeks to hold the company accountable. It seeks to say that in Kentucky, you cannot, by omission, profit while our people suffer. And we at the Attorney General's office want to make sure that every woman who has suffered because of an implantation of surgical mesh where they were not given adequate information is able to find relief. So for those Kentuckians that have been harmed by Johnson & Johnson's surgical mesh but are not a part of a current multi-district litigation that's out there for these individuals, please call my office at 502-696-5389. No company is above our consumer protection laws in Kentucky. No company has the right to deceive Kentuckians and put their lives at risk. And my job is to hold every single company that thinks it can accountable. Thank you. And I'm willing to take any questions, first on what we're talking about here, and then any outside that you may have.
You've asked people who may have had this mesh implanted to call your office, but they won't see any of the proceeds. What do you hope to gain by having these patients calling?
We want to make sure that they have the information on the current litigations that are out there right now that seek to provide damages to women who have suffered. So there's already a multi-district litigation that contains numerous actions and class actions all around the country. We want to make sure that they have the information on that proceeding and can join if they want to.
What will your office request this money is used for if you win this lawsuit?
Well, ultimately, these are penalties that will come back to the state that will have to be likely appropriated by the General Assembly. But going towards consumer protection actions and overall health is certainly something that I'd like to see. Anything that we can do through the use of these funds to make sure something like this doesn't happen again, in my mind, is the rightful use for those funds. All right. Sure. I can't imagine what else you might have to ask about, Chris.
The first question is Thursday you'll go before the Supreme Court.
Yes.
Are you prepared for this? This is an appeal that you've made, having lost the initial case. Are you confident that you can convince the Kentucky Supreme Court to rule on your side in this latest lawsuit?
I'm confident because all of our arguments fall within what the Kentucky Supreme Court has decided in the past. The Kentucky Supreme Court has ruled over and over that spending and the power to spend is solely within the legislative branch. And this is the first governor in our history that's claimed that that budget isn't what the state spends, but only sets a ceiling where he and he alone gets to decide between zero and that amount. That is a significant overreach, and I believe the Supreme Court's going to see it as such.
There were some county judges that had tried to get in on this lawsuit. They've been told that they can't get in on this lawsuit. Did you oppose their involvement?
The Supreme Court rejected that on their own before any action could be taken because it didn't follow their procedures, something that they probably should have known.
Would you have filed to prevent them from joining the lawsuit?
Well, I would have filed to prevent them from joining because their argument and their powers aren't connected to our lawsuit whatsoever. Our lawsuit is about the separation of powers at the state level between the legislature, the executive branch, and sometimes the judicial branch. But county judges are created by an entirely different section of the Constitution than those branches and have entirely different statutes that govern them. There's not one overlap. And in fact, a county judge is both an executive and a legislator because they get to vote on their council. So the two are entirely unrelated, and I see the attempt to join as merely political.
I have one other question for
Okay.
you. Since we have you, thank you for taking the time. We now know the timeline for the U of L lawsuit is now going to go into October. Are you disappointed that it's going to take that long to get to this point, knowing that that case may end up at the Supreme Court as well? We could be talking the next semester, maybe well into the next year before we have a decision on that lawsuit?
Well, I have concerns for that, but the judge was very clear the last time we were in court that he wants to get it right. And he wants to make sure that he has a record before him where he feels comfortable making the initial decision. And I can understand that every judge at the trial court wants their decisions to stand on appeal. So I respect that request. We're looking forward to our next hearing dealing with the accreditation issue. We believe we're going to be able to put forth significant evidence in that hearing, and we believe that the accreditation issue is serious. We believe that the best argument that the other side has made is, sure, we stepped on the landmine, but we haven't stepped off it yet. But the actions the governor has taken violate multiple rules of accreditation, and if we can't reinforce the laws that prevent what the governor has done, then I think U of L is going to see a serious accreditation risk, if not at least a warning in the beginning, and that has serious consequences.
Anybody else?
All right. Thanks.